Before we jump into this courtroom footage, you need to understand something about cases like this. Every so often, a defendant walks into court completely convinced that the entire legal system is somehow conspiring against them. They believe the police are corrupt, the prosecutors are biased, the judge is part of the plot, and the law itself doesn't apply to them. And when that belief meets the reality of an actual courtroom, things can spiral out of control very quickly. Today's case centers around a defendant who not only believes the charges against her are completely fabricated, but she's also convinced that the entire prosecution is retaliation for her trying to protect a child. She claims her rights are being violated, she threatens lawsuits against the police and the court, and she repeatedly insists that the case should be dismissed immediately. But here's the twist. The judge presiding over this hearing calmly explains multiple times that an arraignment is not the stage where evidence is argued or cases are dismissed. Yet despite that explanation, the defendant continues pushing back, interrupting, and escalating her claims. What follows is a fascinating example of how courtroom procedure works when someone refuses to accept it. The judge remains patient, explains the law step by step, and tries to keep the hearing moving forward. But the defendant keeps doubling down. So the real question is this: is she a victim of a broken system like she claims, or is this simply someone who refuses to understand how the legal process actually works? Let's watch how quickly this courtroom exchange turns into pure chaos.
2300820M. This is Van Buren Township versus Lindsay Dineski.
Yes,
Nancy
ma'am, that's
Manning
me.
on behalf of the people.
I'm sorry, ma'am. State your name for me again.
Lindsay Dineski.
Thank you. Today is the day and time set for the arraignment and pretrial in this matter. Ms. Dineski, the way the court staff have you labeled indicate that you're waiving your right to have the assistance of the court-appointed attorney. Is that correct, ma'am?
Yeah, I'm studying to be a lawyer. I would not need that.
That being the case, have you had the opportunity to speak to Ms. Manarino this morning?
Yes. I
Ms.
think all
Manarino,
charges should be dismissed because this is retaliatory action for asking for a child to be protected.
Ms. Manarino, how are we proceeding this morning?
Your Honor, based on my discussion with Ms. Dineski this morning, she is requesting to have the matter set for a jury trial.
I'm actually requesting for dismissal, and she insisted that I either take a plea or go to trial, but I think that it should be dismissed because it's retaliatory and it's in violation of several of my rights, Michigan and federal rights, under the Constitution of both.
At this point in the hearing, the judge is doing something very standard in criminal procedure, explaining the purpose of the arraignment. For anyone unfamiliar with how courts work, the arraignment is essentially the starting point of the case. It's where the charges are formally read, the defendant enters a plea, and the court sets bond conditions if necessary. What it is not is a trial. It's not a place where evidence gets debated, and it's not the stage where the judge typically dismisses charges simply because a defendant argues that they're innocent. That process comes later through motions, discovery, and eventually trial if the case goes that far. The interesting part here is the defendant repeatedly insisting the charges should be dropped immediately because she believes they are retaliatory. While defendants absolutely have the right to argue that a case is unjust, the courtroom has a very specific process for when and how those arguments are made. Ignoring that process and trying to force the issue early almost never works, and sometimes it actually hurts the defendant's credibility with the court.
Plea not guilty.
Thank you. That's the recommendation from Van Buren Township, ma'am, is that they do not oppose personal bond, and that was going to be the court's intent. Set your bond at $5,000 personal. You do not need to post any money, but what you must do is continue to appear as directed by the court until this case is resolved in its entirety. The arraignment having been completed, the next step is pretrial. You've both already indicated that you've had some conversation regarding pretrial. Ms. Dineski, I understand that you have a defense that you want to present. Today is not the day and time to present that defense. If you want the matter scheduled for a jury, the court is happy to schedule the matter for a jury trial. In our interim, there's also a request that you have no contact with Charles Nerswick, Nerswick. Do you have any reason to be in contact and communication with that person?
Yeah, we have children together, and he kidnapped one of our children, which
Your
is
Honor.
what I was actually calling the police about, and he has our child in danger, and they refused to listen. And now she's gone. She's missing. So I will be countersuing Romulus, or I mean, I guess it would be Van Buren. And if the court proceeds with this, I will be also bringing the malicious prosecution against this court as well, because these are erroneous charges and they're retaliatory, which is a violation of my freedom of speech. It's a violation of my right to due process. So if this does not get dropped today and it moves forward, I will be filing under color of law lawsuits against Van Buren and this court in federal court for violation of rights under federal question jurisdiction. So I just don't think it would be a good use of the court's time or resources to continue this malicious prosecution. And I could quote case law, I could quote laws that Van Buren police broke. They completely ignored my evidence. There was obstruction of justice. They said there was sexual discrimination against me because I was a woman. I have all the calls recorded. I mean, it would really be a waste.
In the description, I'll attach a rejected lawsuit where she accused several Greene County officers of not just running her off the road, but then immediately changing to help her as soon as she started recording them. How convenient. She also accused them of the normal sovereign citizen violations, like deprivations of right under 18 U.S.C. 241 and 242, and not consenting to prosecution.
The one who broke the law was Van Buren Township, not myself.
Ms. Dineski, I said it before, and I'm not sure if you heard me or understood that today is the arraignment. Today is the
Yes,
first
but if
appearance where
I
you
could ask for it
respond.
to be dropped at the arraignment. I'm allowed to ask for the charges to be dropped because they're erroneous. So my liberty should not be affected by erroneous charges. I should not have to keep showing up at court and have a bond. That's a violation of my liberty. This is malicious prosecution. Chuck has friends at the Van Buren Township. His father used to be the fire, one of the high, like he was like the assistant fire chief. So there's bias there. They refused to listen to me. He tried to kill me, and then he took our child. And when I talked to the police about it and said that under Michigan law, he should not be with a child because he's suicidal, homicidal, and he's isolating with a child, everybody ignored me. And then they pressed charges against me for asking them to help me.
Now things start getting particularly interesting. The defendant begins escalating her claims, suggesting not only that the police acted improperly, but that the entire prosecution is part of a conspiracy against her. She mentions federal lawsuits, civil rights violations, and something called color of law, which is a term often referenced in civil rights litigation. Here's the reality though, simply claiming a constitutional violation doesn't make it legally valid. Courts require specific evidence, legal arguments, and proper filings before those claims are taken seriously. Threatening lawsuits in the middle of an arraignment usually doesn't change the outcome of the hearing at all. Another key moment here is when the judge reminds her that the proceedings are being recorded and streamed live. That's actually a subtle warning. Judges sometimes do this to encourage people to think carefully about what they say in court, because statements made on record can later become evidence or affect how the case is viewed. And yet, despite that warning, the defendant continues pushing forward with her accusations.
Ms. Dineski, just so you're clear, this matter is being recorded and we're streaming live on YouTube. I only say that so that you may be mindful of the things that you say. Ms. Manarino, you were starting to say something.
Yes, Your Honor, as it relates to bond, I understand that Ms. Dineski has an issue with the no contact. When I spoke with the complaining witness in this matter, he did indicate that he did not have an issue with Ms. Dineski having contact with him as it relates to the two children, the two biological children they have in common. As it relates to any other matter, he would not like to have contact from her during the pendency of this matter.
So, Ms. Dineski, I will ask you the question a different way. Do you have any reason to be in contact with Mr. Nurswick other than to make arrangements regarding the children?
Haley is my child. She's not my biological child, but legally she is my child. I've cared for her for 5 years. I'm the only mother she knows. So yes, I should be able to have contact with him regarding Haley because he kidnapped her legally under Michigan law. I am a parent and I have as much right to her as he does as a biological parent. The court, when gave him custody, used me as a deciding factor as to why he got custody of that child. So that actually, just that particular statement shows that this is about him abusing myself and Haley and using the court as a shield to keep a mother away from a child. And the fact that he took her away from me, she's not been away from me more than 3 days since the day I met her. And he hasn't let me talk to her in 2 months. And that's extremely mentally damaging to her because she already has issues. Because when I met her, a bio mother had abused her and neglected her, and I had to work with her for 5 years to even get her to be able to be at the same level as somebody her age, because she was so behind due to the abuse and neglect and now he tried to kill me. He said he was suicidal and then kidnapped our child, and then used Van Buren police to maliciously prosecute me when I tried to assert my rights to that child and my right to protect that child. So again, the only people who have committed any crimes here is the Van Buren police and Charles Nerswick.
Ma'am, the court will impose a condition of bond that you have no contact with the complainant in this case, except as is necessary to make arrangements regarding the biological children. I heard your request for a jury trial, but I've also listened to the comments that you just made, and I want to disclose to you that I am married to an elected official in Van Buren Township. He is not involved in the day-to-day operations of the Public Safety Department, the issuing agency in this matter. But based on the comments that you've made, ma'am, I'm not sure if you wish to have this case remain here with me, or if this matter should be adjourned to Judge Green's docket. She next takes the Van Buren Township docket with a date available on April 20th for a pretrial conference. How do you wish to proceed?
Is that where I can ask for it to be dismissed?
You can make that request at every hearing, ma'am.
Well, that's what I was doing today, but you said that was not appropriate.
Because there's been nothing received from the court other than the charges. So the arraignment is just the reading of the charges, the setting of bond, and then the scheduling of the next matter unless the parties have reached an agreement. So there's
that's what I'm asking for the agreement, due to the fact I was not given any evidence. I was like, I have proof that Chuck took this and tried to use it in a court to try to kidnap the biological children from me. And the court didn't grant it because it was, again, erroneous, and the court saw through that. But he conspired with the Van Buren police to have these charges brought against me, and he perjured himself. The Van Buren police perjured themselves when they asked for this warrant. I was not given the information. I was not given the information as to what I did wrong. They kept that information from me. I was not properly served on this matter either. I mean, everything is completely improper in this entire case. Plus, it's erroneous and they're false charges.
Ma'am, are you requesting information from Ms. Manarino at this time?
I mean, I called and asked for information back when I first got the letter, and nobody would give me anything. I've called and I left her messages, I think, at least twice. So, yeah, I would like to have every single thing that they use to get an erroneous warrant on me.
Ma'am, based on that, the court will make an indication in the file that you've requested discovery. Now that you've requested discovery, we'll put the matter over to Judge Green's docket. That will be
April 20th at 9:20.
April 20th at 9:20 in courtroom number 3, back on Zoom with Judge Green. Ma'am,
and I would like to know why I would not be allowed to talk to Charles about my daughter, Haley. I will not abide by that, by the way. I will not. That's illegal. And I do not have to abide by an illegal.
April 20th with Judge Green, ma'am. The court will mail notice to the address that we have on file in this matter. Anything else, Ms. Manarino?
No, Your Honor. Thank you.
I do not consent to this, by the way. I do not consent to this interaction. I do not consent to these charges. I do not consent to any of it. It is erroneous, and I will be taking legal action against this court for not dropping this today.
As this hearing wraps up, we see the judge take a very measured and professional approach. Despite the repeated interruptions, accusations, and threats of lawsuits, the judge focuses on the procedural steps required at this stage of the case. Bond conditions are set, discovery is requested, and the matter is transferred to another judge's docket for the next hearing. One of the most notable moments is when the judge voluntarily discloses a potential connection involving a family member who works as an elected official in the same township involved in the case. That kind of transparency is actually a critical part of maintaining judicial fairness. By giving the defendant the option to move the case to another judge, the court is ensuring that there can be no appearance of bias in the proceedings. In the end, the case isn't dismissed like the defendant demanded, but she is given the opportunity to continue presenting her arguments in the proper legal setting. The real battle in this case will likely happen during the upcoming hearings, where evidence, discovery, and legal arguments will finally be examined. Now we want to hear from you. Do you think the defendant is genuinely being mistreated by the system, or is this simply someone misunderstanding how the legal process works? If you found this courtroom moment as fascinating as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.